When a mutual insurance company demutualizes, who gets paid the compensation, the employer or the employees? To find out, you have to read Columbia Memorial Hospital versus Hinds, but it's 18 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases in 5 minutes or less. This is the episode on the case of Columbia Memorial Hospital versus Hinds and several other associated cases. This can be found at 2022 New York Slip Opinion 03306, published by the Court of Appeals on May 19th of 2022. This is a civil case. The issue in this case is when a mutual type insurance company converts to a stock type insurance company, who gets paid the compensation or the consideration for that conversion? Is it the medical professional employees or the employers who acted as the administrators of those policies and did all the administrative work? That's the question. That's the issue here. The answer the holding gives us is that it's the medical professionals. The law you have to understand this case is New York Insurance Law 1211A, which says that in a mutual type insurance company, all of the policyholders of the mutual insurance company are the shareholders of the company, have voting rights, but the law defines them, the policyholders, which in a mutual type medical malpractice insurance would be the medical professionals who are the policyholders who could be sued and own the policy, or the sole policyholders generally. They are the sole policyholders and the shareholders of the mutual type company. And New York Insurance Law 7307, which defines what happens when the insurance law has a bunch of different provisions in that area of the law of how different insurance companies can change or convert from a stock to a mutual, from a stock type to a mutual type, or a mutual type to a stock type, all kinds of different configurations. The facts in this case are that MLMIC, which is Medical Liability Mutual Insurance Company, is a medical malpractice insurance company. That's a mutual type. So all the policyholders are the medical professionals. And National Indemnity Company, which is owned by Berkshire Hathaway, wanted to buy Milmic. When I did medical malpractice, we called this Milmic, for $2.5 billion. The New York State Department of Financial Services approved of this conversion under that statute, Insurance Law 7307E. So $2.5 billion is going to go to the shareholders of Milmic. And the New York State Department of Financial Services said if there's a dispute about who's going to get this money between the employer or the employee, it goes in escrow until it's sorted out. There were a lot of disputes where several employers, the companies of doctors or the hospitals that employ these doctors, said, we want the money. We want our portion of the $2.5 billion, not the doctor who we've been paying the premiums for. We've been paying all the premiums. We should get the money that goes to demutualize this insurance company. Now, there were 8 cases that are addressed in this particular appeal. And in each of these cases, basically the medical professional employee is the sole named policyholder, and the employer pays the premiums and does all the administrative work, chose the premium in the first place, the policy, and the employer argued that it was entitled to the money. Now, the trial courts in the various of these actions sometimes held for the employee, sometimes held for the employer, but at the appellate division, the employee medical professional won every single time, and it goes to the Court of Appeals. And they hold that the plain reading of that New York Insurance Law 7307E says that the compensation or the consideration has to be paid to the policyholders. And the policyholders are the medical professionals, not the employers. So they say it's simple. We're going to apply the law. The doctors or the medical professionals get the portion of the $2.5 billion, not the employers. Now, it's interesting, and this is sort of the dicta of it, the employer's arguments. They address the employer's arguments, and they make 2 principal arguments. The employers say, well, we are the de facto owners of the policies because we picked it, we paid it, we've done all the administrative tasks related to it. And the Court of Appeals says no. And the second argument they make is an unjust enrichment argument. And this is interesting because they say the doctors would be unjustly enriched by getting this money when we've been doing all the work. And the Court of Appeals says no, the doctors, the medical professionals are the policyholders pursuant to the law. And they also go through what the elements are of unjust enrichment. The other party is enriched at the first party's expense, and it's against equity and good conscience. Basically, it's not fair. And they go through each of these and they say none of these elements are present here. The doctors, under the law, should be getting their consideration, and we're going to apply the law. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.